and the employee retention credit. So what people are faced with is, what do I choose? What is the right loan to take? What do I have to be at risk for personally? What do I have to be at, what I have no personal guarantee for? How much can I get? The one we're all hearing about is the PPA. It's a forgivable loan. They all come under SBA Chapter 7A. And what the allowed use is rent, payroll, mortgage interest, and debt you incurred before February 15th of 2020. What it's coming down to is 2.5 weeks times average of 8 weeks payroll in 19 rather. Once you get that information, that's the max you can borrow. There's a forgiveness on this one. It's great stuff because you have a chance to have this forgiven, the interest and principal for that. They cap it out at $100,000 of salary, not benefits. And the devil is in the details of this. I've got stacks of reading from each definition what the full-time equivalent is, comes about, who the money is going to. The next one is the economic disaster loan. I'm just highlighting the top level of this. That's a loan that you have up to $200,000 is not personally guaranteed, but you have to pay it back. The last is employee retention credit. So going down the decision tree is how much money do you need? What are you going to do with your business after this comes through, and not losing key employees. It's hard to get great staff, as we can all imagine, and keeping them and finding the best way to keep them comes about.
Let me ask you a little bit about the applications, Jay. I've heard a lot about business owners talking about applying for the loans. I've heard about accountants and other types of advisory firms who are offering services to their clients to help them with the application process. I've heard about how some banks are doing a good job processing the applications. Some banks are a little bit backlogged in processing the applications. What are some things that people know or should know about the application process? How quickly do they need to get it in? Who should they work with to get help on these issues? What are your thoughts, Jay?
The sooner the better, because there's a limited fund. They believe they're going to go back to Congress to ask for more. But getting up on the line and standing up for it is very important. The one you go to, the PPP, you go to your bank with, not the local branch. They're all doing it online. They were very late in getting these forms up and what information that they want to support it, because the SBA is not reviewing creditworthiness. So to get it out faster, they want the bank to ask certain questions, support for the payroll that they had. So that's usually a listing of all the payroll paid in 2019 and by person, to make sure that the payroll is not over the $100,000 limit per person, because that's one of the exclusions of what you can borrow money at.
Can I just jump in for a second?
Sure.
Yeah. Go ahead, Porpoise.
Yeah, because it's really important that business owners, when they're thinking about applying for these loans, in order to make them forgivable, that they've got the proof that this payroll was for employees that they had to pay, as opposed to that they chose to. So when you're paying somebody who's not working, who's home on leave, when you otherwise wouldn't have to pay them, you got to really document the fact that they were required to be paid under the new laws.
Thank you for adding on to that. You're quite right. That's where I said earlier, the devil is in the details. For example, in the economic injury disaster loan, they call it a $10,000 grant. You get that money, and if you convert to a PPL, that comes off of how much you borrow. It's not the same amount. You take that $10,000 grant off of what you borrowed. So there's a lot to be done in deciding which employees you keep, how do you fund them, what if you're subject to how many employees you have. If you have the 50, which is some exclusions for small business of the first act, and which I assume Porpoise you'll be talking about. And then you have the 500 level that comes about, and also what industry you're in. If you have a code 72 for your business code, which is hospitality businesses, there's rules that change for them. There's different rules for aviation companies. So it's very hard. I'm giving you a broad background on what's available for people, but they should act now and get some help. Their advisors, there's two parts, is the actual application time. The most that could be charged is 1% of the loan, and the banks pay for that, not the client. The banks are obligated, and that's why they drag their feet on it, on how much they're going to pay. But it's right in statute, it's 1%. Accountants can't change more. The AICPA came out with an opinion 2 days ago that said not applying for the loan, but the time involved in deciding which loan and bringing the accounting records are not part of the loan application process.
Jay, can you give us, for those who aren't familiar with AICPA, that initialism, and tell us about the guidance that they're providing and how that's helpful for the CPAs that are part of the organization, and then, of course, for the end clients?
Absolutely. The AICPA is the American Institute of CPAs. They have a very good website along with the SBA about particulars of the loans. One of the things they fought at the beginning of the PPA, the SBA wanted to subtract from the amount you could borrow the payroll taxes, the FICA and the federal income tax that was being withheld for employees. And what happened was the AICPA, through a letter campaign, got the SBA to go back to what the senators in Congress approved, was on the gross wages.
Jess Coburn, let me go to you and see if you have any questions you'd like to interject. And of course, I'll go to Porpoise as well. Any questions that you would like to interject for Jay Jackler?
You know, the biggest question that comes up, Jay, that I hear over and over again is, what's the difference between the EIDL and the PPP? And can't I just apply for both of them? And aren't they both going to be forgiven and turned into a grant?
Only 10,000 of the EIDL will be turned into a grant, up to 10. The PPP is forgivable if you spend it 75% on the appropriate payroll, and the other 25% could be spent on rent and utilities, which comes about of how you can calculate the loan. I'll give you an example. If you have 3 people making $52,000 a year, the average weekly pay is $1,000. So 1,000 times 8 is 8,000, times 2.5 is 20,000. So the most you can borrow is 60,000. Of that, you have to spend at least 75% of the 60,000 on payroll. You can spend 25% of it on rent and utilities. Utilities would also include reimbursing your employees for their internet and electric sitting at home. That reimbursement is excludable from their income under Code 62. It's not part of adjusted gross if it's part of an accountable plan. If you just give them a stipend, a flat amount with no accounting, it's taxable income. But if you give it to them as a accountable plan, it's not a problem.
Thank you. Porpoise, I think you might have some questions for Jay that you'd like him to clarify. What kind of comments or questions do you have for Jay?
Yeah, I guess I'll just say from the start, before I even get to questions, this is why we have tax attorneys and CPAs, because this stuff is so technical and so code driven, and one misstep and you can find yourself disqualified for the forgiveness. And I guess the question I would have for Jay is your entire payroll potentially forgiven?
There's some exclusions. That's a great question. because payroll over 100,000 or for workers out of the country is not excluded. And it's also independent contractors. You know, for years, people touted how I can make someone an independent contractor. Not rightfully so, but they're saving the FICA and Medicare tax. Now they're getting kicked because it's not a reimbursable, loanable amount for the loans, at least the PPA. That's why some people look at the EIDL loan to go for that. That's non-forgivable. It doesn't mean it's a grant other than that $10,000 advance. But it may provide more funds in the cap depending on what the nature of your expenses are.
And does it matter whether your employees are full-time or part-time?
When it comes to it, you have a full-time equivalent calculation that you have to maintain. The employee base as of February 15th you've got to look at June 30 to make sure you either hire them back before then. And that's an interesting calculation. I'm still waiting for the attribution rules to come out. I'm wondering whether if you hire your mother-in-law in place of an employee, does that still fall under the $100,000 cap or not? That's going to be determined in the next week, I guess, unless you have an answer. But that, for smaller companies, those are the things that stay in the loop about these type of changes.
Jay, who are some of the people that should think about applying for the loans? How can people self-assess to determine whether they should be applying for these loans? And then maybe to explain that, maybe you can give a few examples of people that would not qualify for the loans. Who are the business owners and individuals that should not bother applying for these loans?
On the PPP, you're capped unless you're in the food and beverage or franchise, a business that's 500 employees. So otherwise, it's a no-brainer. Please do it right away. Time is of the essence in getting in before the money runs out. The EIDL, we've got the employee retention credit, which is just a credit. If you don't get the loans, that comes automatically. Again, those are the types who should be borrowing the money. I would say most clients, unless they don't have an economic need under this, and I don't know of one at this point that I've come across who hasn't been affected by the pandemic.
Porpoise, you have another question for Jay?
Not so much a question, but maybe another comment. Something Jay said I think is really important to remember, and that is that these federal agencies are, we like to insult them and be exasperated by them, but in this instance, I got to say they are working overtime and in their rulemaking and putting out regulations. And the Congress put together a comprehensive bill very quickly. But it's up to the IRS, the Department of Labor, the other administrative agencies to actually implement the new laws. And things are changing. Things are changing sometimes daily, sometimes hourly. So, when the Families First Coronavirus Response Act was first signed, you had lots of law firms putting out their interpretations of it and getting out alerts to clients, which was great. But within a week or two, a lot of that had to be modulated because the agencies were coming out with the actual rules about how things were going to work and how much people had to be paid and things like that. So it's really important to not rely on what you see on the internet because it might be outdated, even if it's just a couple of days old.
Jay, your thoughts?
He's right on target. It changes daily. I woke up this morning and went to bed last night checking the websites to see what had changed. The IRS has made changes in the various tax laws. They've changed the filing dates of when estimated payments are done. In fact, I put something up on LinkedIn from the AICPA, American Institute of CPAs, as we discussed, what is a report of those changes made late yesterday. So staying on top of it or having business advisors who are doing that for you and who inform you regularly is important.
Jay, we talked about maybe that you'd like to provide a specific example, obviously without disclosing your client's name. If you could give us an example of a client that you've been working with and how they're applying and what that example could illustrate for folks, if you have one.
I have a couple of them. It seems the banks didn't have the right forms. They weren't ready on the website when they're supposed to be. We're waiting to find out, today is the day that independent contractors can also apply for loans. And if it's anything like what happened a week ago, no one was ready. What happens when you apply for the loan, you need to assemble certain documents different for each bank. Someone will accept the 18 data. Some will want your 19 tax returns. Each bank is different. You got to see what the bank, and you can't apply to multiple places. I'm finding that some people are precluded because they go to a bank and say, you didn't have a business account with us on February 15th. And so the client said, I've been banking with you for 20 years. So, well, we don't have the right code on your account and we can't fix it. Now that's a bank rule, not an SBA rule. So a lot of people are re-examining their payroll service connections and bank connections, and they may be changing after this is over by either the great response or lack of response and reporting information being made to them.
Yeah, that's an important point. I spoke to a friend of mine, an immigration attorney, earlier this week who was having that very issue. And it was with a big bank. It wasn't with a bank that had been turned over or a local community bank. And a lot of times small businesses will have several accounts, some personal, some business, depending on how small it is. And this was a solo practitioner who had personal accounts and business accounts at the same bank. And they were having trouble verifying the business accounts for some reason.
Hey, Jeff,
don't forget, they have a lot of folks working from home too. So your local relationship partner at the bank might not be readily available.
Sure. And they're not at the local relationship, other than yelling at them, they're going to corporate, is what I'm finding. They have no idea what's going on. In fact, I've sent to several of the loan officers some documents from the SBA site saying what the bank has to do. And here's a copy of the note you can write. The SBA's provided it.
Jess, I think you wanted to comment about a comment.
I did, Jeff. So we received a comment that was a good question for Jay, and it's, will the grants be taxable to the businesses?
A grant is non-taxable to the business. And the reason why is you pay the payroll and you net it against the payroll cost, but it will not be taxable. It won't be taxable income.
Jay, I think we covered now the loans, and I think you had a couple of other, or at least one other program that you wanted to discuss when I interrupted you earlier. Please continue and give us a brief synopsis of the things you wanted to discuss.
I was going to mention the employee retention credit. You get 50% of up to the first $10,000 of wages, including healthcare costs per employee. And that's important when you talk about payroll costs. It's just most of the payroll services have gross wages, but they don't all have the retirement contributions and the health insurance amounts. So you got to take that information and add that on for purposes of your various loans. People are missing out on that. And if that's the one nugget they walk away with, is to make sure they get the benefit costs in addition to the payroll. Even someone making $100,000, the law has changed. It's 100 plus your health insurance and your pay and the retirement plan costs. The employee retention credit has to do with the when do you get it back? You're ineligible if you get a PPP loan, and they're giving you penalty relief for not filing your payroll taxes, which is pretty hard to do remotely sometimes. People who've left who don't have their codes. So I would think those are the big three would be the payroll protection program, the economic injury, in the sub-grant, the Emergency Economic Injury Grant, and the Employee Retention Credit. There's also SBA loans, the larger ones where you go for credit worthiness for disaster loans if you need a larger sum or a bigger company and don't qualify for the other ones. Again, if I get a question on a particular one, I could focus on it. You could spend the day talking about it, and I think that people are looking for a summary.
Thank you. Jess, I think you might have another comment or question for Jay Jackler.
I think we covered the big ones that I can think of, Jeff.
Thank you. I was going to ask you, Jay, your thoughts about advising clients. Clients could, of course, hire you to help with some advice. They could really talk to their bankers about some of these issues, or they could try to figure it out for themselves. Maybe there's another choice I'm not thinking of. What can individual business owners do? Maybe those three choices or another one I'm not thinking of. What are their choices to go forward, and what do you advise them to do?
They really need to sit down with a team. They've got to talk about what employees they want to keep, how long they want to keep them. Do they want to fund the 8 weeks to keep people online? Is the 8 weeks going to be enough coverage, or are they going to need more when they try to get back in business? So who are you to talk to? I'm doing a lot of consulting around the country and asking questions, and each person's situation is unique. And that unique facts is what you've got to fine tune towards to make sure you get the right choice. But those, your accountant, your attorney, are the key business advisors, your banker, and that combination should be, as long as your HR manager should be consulted.
I imagine there are a lot of business owners out there who are facing dire straits in very difficult financial times for themselves and their employees. And the idea of hiring a consultant or a CPA may be a little bit of a challenge. How would you advise people to make some of those decisions about investing into getting some help on this?
How can you not afford? This is your livelihood. You either got to do the research yourself, but it's many people, it's hard to tell them to be their own surgeon. They have to go to 8 years of medical school. And in this case, you need advice, even if it's a half hour, an hour's worth, to at least get you thinking of what the availability is in help. It's very important, Jeff, that people talk to somebody.
Thank you, Jay. And how can people reach you? What's the best way for people to reach you?
They can either reach me at jjacklercpa@gmail.com, or they can reach me at 561-212-6648. We can set up a telephone call, a video conference, and I can email them specific charts and analysis towards their business.
I think we do have a slideshow that you are making available, and thank you for doing that, that we're going to be able to share through a Google Drive, and there will be a link where people can click on that and look at the slideshow that you created for them. Tell us about basically what's inside that slideshow and why people might want to take some time to look through it.
It gives, one of the things in there is a chart. It compares the major 3 loans, and I went through very quickly. And it provides more details and examples of what loans they can take, how the calculations work. It may lead to other questions, but at least it should get people started to think about what are the alternatives and what questions do I have after I look at that.
Thank you. I know we just shared as a comment the hyperlink to the Dropbox account. And so if folks are looking on our live stream on Facebook or on YouTube, they should be able to see that link in the comments and be able to click on it so they can access the document. And of course, as Jay mentioned, I believe it's jjacklercpa at gmail.com. Is that right?
That's correct. Initial J, my last name Jackler, CPA at gmail.com. If you're not happy with me, it's George Smith.
Thank you.
Your humor, Jeff. I had to work something in.
I love it. Let's now move on to Porpoise Evans. D. Porpoise Evans is an employment law attorney, and Porpoise has a lot of great experience working. And I'll put up a slide here so people can review briefly his background and how he works with public and private companies. And of course, there are a lot of legal disputes that maybe happen related to employers and employees. There's a long list, actually, things like discrimination and harassment and hourly wages and all types of compliance related issues, depending on the industry that different employers are working in. Porpoise, perhaps you could give us, before we discuss some of the issues today, just a little bit briefly on your background and a sort of comprehensive list of the issues that you would normally talk about with clients.
Well, sure. I'm a labor and employment attorney. For those that like to use shorthand, a lot of times people will just say a labor attorney. But in my business, when we say labor, we talk about traditional labor. We're talking about labor unions. It's a really small part of the practice for most folks these days because the unions have been so weakened. I guess you could say the union busters won in many ways. So really, my 90% of my practice is employment, not labor. I spent the first 14 years of my career practicing in big firms. Now I practice in a small firm, an office in Coral Gables and another in Fort Lauderdale. We have about 20 attorneys that try to look at all the needs that small, medium businesses have. Serial entrepreneurs are a big part of our clientele. And not unsurprisingly, a lot of international work because of our location here in South Florida. Personally, I focus on all things labor and employment, and that involves litigating as well as advising. The kind of the big three for litigation tend to be, as you said, Jeff, discrimination, harassment and discrimination, wage and hour claims, which really means unpaid overtime for the most part, and non-compete agreements, fighting to enforce them, fighting against them. Those are the things we find ourselves in court or arbitration with. And the other 50% of my time is involved in advising and counseling clients who have questions about those things, who are trying to stay out of trouble. I spend a lot of time on the phone fielding questions and in clients' offices, and these days on the internet, training managers. What does it mean to have an anti-harassment policy? What do you do when an employee complains? Another big part of my practice that dovetails with that is anti-bribery, anti-corruption work. So really anything that employees can do to get a company in trouble are things that I tend to focus on. And that's no different whether those employees are working remotely or working in a brick and mortar traditional office setting.
You touched on something I'd like you to expand upon, which is the idea of hiring an attorney in a proactive way versus reactive. If I'm an employer and one of my employees says, I'm suing you, and they hire an attorney and there's a suit, I'm going to probably realize reactively that I should have my own employment law attorney. So that would be reactive. Tell us about, in your mind, some of the issues that you can work with an employer on that might be more proactive when there isn't already a suit filed or a complaint. What should they be doing with an employment law attorney when there's not a lawsuit filed?
Well, that's a great point. An ounce of prevention is worth a pound of cure in this instance, as in most. And most people don't like to have attorneys on retainer. It's a pure cost center, the way they look at it. And I get that, especially for small businesses. But you know what? Litigation is really expensive. Litigation, especially for non-compete agreements, can be very front-loaded. And the fact is, once you're drawn into court, you don't really have a choice, and you're going to pay an attorney to defend you. And in most cases, in the employment realm, you're going to pay the employee or former employee's attorney as well, because there are fee-shifting statutes that very rarely work to the employer's advantage. So proper planning, proper understanding of what the employment laws are, proper policies that might, there are one or two policies and procedures that a company can do that can make you bulletproof against a lawsuit. You still have to defend, But there are one or two things that can almost assure you a win in a discrimination lawsuit, that if you haven't thought about them and talked through them with somebody who understands them, it could cost you a lot of money on the back end, where it would have been pretty modest on the front end.
You and I have talked a lot about referral strategies, as my area of expertise is in referral strategies, especially for financial and for legal professionals. Tell us about some of the referral sources. For attorneys, generally, you would have the clients themselves become referral sources. In other words, they hire you, you do a good job for them, and they let you know about a colleague or a friend that could also use your help. Aside from the clients themselves being referral sources, who are some of the other referral sources that are able to find opportunities for you and send those referrals over on a regular basis?
Great referral sources for a lot of attorneys tend to be other attorneys. We're in a world where specialization is king. Very few people practice what's called door law, where they take whatever kind of case walks in the door, and they have the, I guess you could say, the luxury of being jacks of all trades. Personally, I think it's a luxury to be a specialist and not have to try to know a little bit about everything. So, my friends who only do probate work, or who only do tax work, or mergers and acquisitions, immigration attorneys, those tend to be great referral sources. By the same token, because I'm an employment attorney, some of my best referral sources are HR directors, HR managers, payroll companies, where the day-to-day work that they're doing touches employees, and but they don't necessarily have the legal expertise. They've got enough knowledge to spot issues, and those are some of the best clients, are the ones who actually know their problem areas and can recognize they need help to deal with them.
I was speaking recently with someone from ADP. You mentioned payroll companies. I think ADP is one of, if not the largest, payroll company. And it was just amazing to me as he was describing the comprehensive work that is involved in what they call HCM, human capital management. So a company like ADP, traditionally maybe known for payroll, is actually providing a lot of services, including recruiting and some sort of training options as well. Tell us a little bit about payroll companies and how you've been able to build relationships with them as a good referral source.
Payroll companies are great referral sources when they're not thinking small, but they're thinking large. Their clients are companies, and many times HR directors, HR managers, CFOs within the companies, and the ADPs and the Paycoms of the world have expanded their suite of services, but the relationships I have, even in ADP, I've been able to build because they recognize that a lot of what they do is a good start. The HR world is different than the employment law world. It's kind of like the difference between a triage nurse and a surgeon in many ways, or a PA and a surgeon. And so you can get a lot of the basics until the proverbial mud hits the fan from ADP. You can get great off-the-shelf policies and procedures that can give you a good start, but a lot of times they're not state specific, and most of the time they're not employer specific. So what I deal with a lot of clients is they've gotten a good model from their payroll provider, and several years later they take a look at it and they said, this really doesn't fit what my business does. I'm not sure it ever did, but it certainly doesn't today. And then I'm able to go and sit with them and modify, say, an employee handbook or a work from home policy that they had never thought about before, a disaster policy. We're in South Florida where we have hurricanes. Anytime you have a hurricane, I'll have a flood of calls. Can I make people come into work? Can I fire somebody who tells me they're scared and don't want to come to work? And I say, well, do you have a weather policy in your handbook? And half the time they say, well, I haven't looked at my handbook for years. And I'll say, well, it's time to sit down with me and talk about that.
Thank you. Another referral source that I was able to introduce you to recently was an HR consultant. So an HR consultant, in this particular case, she was a former employment law attorney, still licensed as an attorney, but practicing as an an HR consultant. For those out there who maybe don't understand the difference, what is the difference between an employment law attorney and an HR consultant? What are some of the things that you would both do that are the same? What are some of the things that the HR consultant would do that you don't do, and vice versa?
Yeah, many times an HR consultant is a really good, cost-effective resource. I like working with them, especially for my clients that need a lot of hand-holding, because they don't necessarily want to pay an hourly attorney fee in order for really just run-of-the-mill questions about employee relations that might not have a legal aspect. Then there are HR consultants like the one you were just mentioning who have a legal background. And they too are good partners. Sometimes we have a ton of overlap because they will do things like go in and do training, do internal investigations of complaints. A lot of times it's good to have even the legal HR consultant working hand in hand with your attorney, because you can have issues of privilege that arise, and you don't want your attorney doing the investigation, but you want your attorney maybe hiring the HR consultant and having a wall, but still working under the rubric of attorney-client privilege. What HR consultants won't do is try your case for you. They won't go to court. They won't defend you when you get sued. And don't forget, suits come not only from former employees, they come from current employees as well.
Thank you so much. Let's get into a little bit on our topic today. I'm going to throw up the banner here. It says, what are the top issues related to employment law that employers should know today? And start with something general, and then we'll get into a few more specifics.
Well, we've gone through a lot of them, but really thinking about the work from home environment, I think Jess made a really good point, which is it's not home to work, or it's working from home. And I've been telling my kids this too. This isn't a snow day. You guys are really expected to work when you're there. So employers have to not only have expectations of their employees, but they have to recognize that their obligations don't necessarily stop at the door. So some of the issues that I've seen over the last couple of weeks have to do with disability discrimination, religious discrimination. Both of those, it's really important that you're able to make reasonable accommodations to your employees and to engage in an interactive process if they ask for certain accommodations. I've seen some issues arising regarding age discrimination because of tech issues and comments that people might make about people of a certain age not being with it enough. And for what it's worth, I think it's fair to say everybody on this call qualifies as an older worker because we're over 39 years old. And that's where age discrimination starts, is age 40. So a lot of people are surprised to hear that, but older workforce doesn't just mean 65 and older. It means 40 and over. We have issues regarding layoffs and versus furloughs, how to do it right. Tracking time is a huge issue these days, and I'm glad to see it coming up as an employer concern, because frankly, it's a concern that people should have all the time, is tracking hours and paying attention to classifications. And there's two kind of classifications that dominate much of my world. One is exempt versus non-exempt employees, and that by exempt, it means you're not entitled to overtime. Non-exempt employees are entitled to overtime. Many employers will believe that a salaried employee is automatically exempt, and that's not true. Exempt employees do need to be salaried, but not every salaried employee meets the test for an exemption. So what I find in a lot of the wage and hour suits that I defend are misclassified non-exempt employees who are classified as exempt, getting paid a salary and never getting paid overtime. That's that really needs to be keyed into today when people aren't even in the office where they have FaceTime with you.
Let me, if I can, interrupt for a moment. I want to go to Jess and then I'll go to Jay for their questions. Jess Coburn, tell us your thoughts from your perspective as an IT consultant in an IT company, some issues that you're seeing that you think that Porpoise should address. You've been working with a lot of your clients, Jess, who have just started with work from home employees, and they've consulted with you about getting the IT up and running and secure. what are some issues that you'd like Porpoise to address?
Thanks, Jeff. So I've noticed two things as a recurring issue. One is, and Purpose talked to this briefly about having a weather page within your employee handbook, but what about having a telework or a telecommuting policy? A lot of businesses have sent their employees home and just said, hey, go home, and really didn't put any thought into this. What could they do? The other one, Porpoise, is we've had employees that, for customers that have come back and had to run an Ethernet cable across the room. And the concern there is, oh my God, what if that employee trips and falls? Is that going to be, a workers' comp issue? What are we going to do there? So if you could talk about maybe one or two of those.
Sure. You asked whether you need to have a work from home policy, and the answer to that is no. The law doesn't require you to have policies in place, but should you? Would your employment attorney tell you you should? You need one? And the answer to that, I would say, is yes. It's something that I've been working with people on, preparing either a standalone policy or integrating one into an employee handbook. But I think it's really important. And some of the issues that you and I guess I have raised are typically what needs to go in there. For example, you need to have you need to address how you're going to secure client files, for example, how you're going to protect your intellectual property and your client's intellectual property, protect any privileges that you might need to, HIPAA protections. Those type of issues come to the forefront when you have people working remotely and you're adding layers of storage, safety. If somebody is working from home, the home is now the workplace. Where are they working within the home? Is the entire home that could be littered with roller skates and razor blades going to be, a new minefield for the employer? Maybe, and we can talk about workers' comp next. And as important as any of those things, how is time being monitored? How are the employees, if they're hourly employees or if they're salaried, how are you clocking their time? Is it the same as when they were in the office? How are you managing it? How are you checking to be sure they're actually working when they're clocked in? Those are all things that I would address in a policy. And just following up on the question of workers' comp, I will tell you that I think we have a nationwide audience today, and every state does administer its workers' comp separately. But the home is the workplace, and work from home employees can file workers' comp claims. The question is, it's kind of a two-part question. They have a claim if they have an illness or an injury that arises out of and in the course of their employment. So is it something that are they doing something as part of their job, and were they doing it on the clock? Those are two really key questions for whether you're going to have a legitimate workers' comp claim for them. So, for example, somebody's making their coffee before their workday starts, and they spill a hot coffee, burn their hand. Is that going to be a workers' comp claim? Probably not. But let's say they do it during the workday, at noon, then it probably is going to be a potential workers' comp claim. Let's say they're on their lunch break and they trip over a roller skate and twist their ankle, or maybe let's make it a little more black and white. But let's say that they're out, getting their kids in from playtime and making sure they get back into home learning, and they twist their ankle in the backyard. That's probably not going to be a compensable workers' comp claim. Let's say that they are set up though in their nursery for their new home office, and it's littered with things on the floor, and they trip on something and twist their ankle. There's a good chance that is a workers' comp claim, and there's a good chance you could have addressed that by dealing with safety issues when you sent the employee home to work.
Thank you. Let me go to Jay Jackler. Jay, we only have about 5 minutes left, so if you could, just a brief question for Porpoise so that we can get into wrap-up mode as well. Jay.
Question, as you said, about tracking what employees do. If I want to use new technology, keyloggers or something else of that nature, that do I need to put disclaimers on if employees are logging into the company mainframes as an extension? Does it make a difference if they own the computer or the company provides a computer also?
Well, the default rule is when you're using an employer's equipment, you have no rights. When you're in the office, you can be sending private emails. If you're sending them over your employer's email, then you have no right to privacy in those emails. If the employer knows that you send something that's HIPAA related or attorney-client privilege, then maybe you do have some rights. But that doesn't change when you go home. And in the ideal world, the company will send you home with a company laptop. Or if you're going to be using your own equipment, your access to the business will be through the company's cloud or VPN, as opposed to just straight having everything having on your home computer. So if you're working through the company's equipment or their IT system, then the company has every right to track what you're doing, to track keystrokes, to know what websites you're visiting. It's a little more complicated when you are working on your home computer, but
Right.
with the proper notices and in some instances, you might have to have consent from the employee. But if you deal with it up front, you can, as an employer, as the company, you can essentially take back control of whatever the employee is doing on company time, and you can have a right to it. You can install trackers on their individual computers as long as you have notice and consent.
So that's a good reason to call you sooner than later.
It sure is.
Yeah, I like that we're reflecting back on that concept we raised before about being proactive for employment law attorney consultations. Maybe if you wanted just to recap a quick list of business owners are out there, they're thinking, well, I haven't had a lawsuit yet, so maybe I don't need an attorney. But what are some of the, if you could recap a list, or even if you had others to add, what are some of the reasons why business owners be reaching out to an employment law attorney today? I was thinking specifically about those employment handbooks that you were talking about, and whether they have them or not. They're probably not being used. A lot of folks don't have them, and those who do have them, they're not accurate and they're not being followed, so they're not as valuable as they could be. And if you could elaborate a little bit on why should a business owner contact an employment law attorney today?
Yeah, it's all about risk, controlling risk. You can't eliminate it, but you can control it. You can develop the necessary defenses to a potential lawsuit. In many cases, you can avoid the lawsuit. And in many cases, you can have happier employees just through transparency. Not everybody's going to be happy with all the policies that you have in that handbook that your attorney has helped you update in order to evolve with the times. But knowing what the policies are and not being surprised by them will help with your employee relations.
Thank you.
Auditing, and I can't not stress auditing whether your employees are properly classified and that you're not misclassifying independent contractors. And that's really important today, just as Jay was talking about.
Thank you so much. Just your final comment, Porpoise, and then I'll go to Jay and then to Jess. Just in a sentence, as we're at our last minute, final comment.
That's it. Having an employment attorney on speed dial is a really good asset these days. Certainly doesn't have to be me, but having somebody who understands the pitfalls of the workplace, even if it's a remote workplace, can save you a lot of heartache going forward.
And can you just share your phone number or email if you'd like, so people can contact?
Sure. Best way to contact me is email PEVANS, that's P like Porpoise Evans, at pbyalaw.com. It's like peanut butter, yellow apple, LAW.com. And my phone number is 305-377-0086. That's our main line.
Thank you.
Email is best.
Thank you. Jay, your final comment, just in a very brief moment as we are wrapping up. Your last comment, briefly, please.
Take the money, get it as soon as possible, save your business. There are also in my presentation, which are tax provisions for business, which you can create, look back and get money back from previous tax years. So talk to your CPA, find out what's available for you, get something customized for your best well-being.
Thank you so much. And Jess Coburn, reflection on our executive virtual roundtable. Your thoughts on our meeting today?
I think it went fantastic. I know there's a wealth of information and we only touched on the tip of the iceberg. I encourage all business owners, CEOs, and leaders to look for the Facebook page, South Florida Businesses Helping Each Other, and join the Facebook group that's with the same name. It's a great opportunity to share that information. Really, right now is when businesses should be helping each other. I'll be sure to post the slide with all the contact information after we're done.
Thank you so much. And I'm Jeff Tockman, the Referral Navigator. You can contact me at thereferralnavigator@gmail.com or 561-755-7764 if you'd like to talk about generating more referral business. With that, we will all wave and say goodbye, and we'll end our session. Thanks, everybody, for joining us, and we'll see you next week.